Hi again, Attorney Steve Honor. We're talking in this episode about adversary proceedings and the In Re Barbosa case. Okay, this is a real interesting case about the intersection of bankruptcy law and copyright infringement law, and what happens if you're a willful infringer of copyright. And let's just say you're going through a BSA software audit or a Autodesk audit. One of these companies is trying to hold, or any other copyright holder that's trying to hold you liable for copyright infringement, and you go through a settlement process and you can't settle. You go into federal district court with your federal copyright claims and you lose, and you get hit with willful infringement, willful copyright infringement, and then you say, well, you know what, I'm going to bankruptcy, I'm going to wipe this thing out, poof, it's going to be gone, done with it, so you wasted your time. So this video is going to talk a little bit about the intersection in this area and adversary proceedings in general. So let's go, without further ado, to the Attorney Steve litigation whiteboard. Okay, so we got a lot of stuff on the board here, and so I'm just going to go over this with you. Try to follow me if you can, okay? We are talking about the In Re Barzos case. For you legal buffs who want to look it up, 545 Federal 3rd 702, 545 3rd 702. Okay, we are talking about adversary proceedings. Okay, first of all, what's an adversary proceeding? Plain and simple, let's make it easy. It's a complaint that's filed in a bankruptcy court. There are lots of different grounds where a debtor or a creditor can file a lawsuit in a bankruptcy court setting, whether you're filing a Chapter 7, Chapter 11, Chapter 13, some of the more common bankruptcies. This is something that you often see is a litigation in the bankruptcy court. The fancy name is adversary proceeding. You can find my website and more information at adversaryproceeding.com. Tell you a little bit more of the details. But let's get back to the In Re Barzos case, okay? So this was a case, I'm not going to go into all the factual details, but I want you to understand just the basics. You have a husband and wife, Luciel, I'm going to try to pronounce it, Albaran and Antonio Barbosa. Okay, so those are our husband and wife team, and they were in the business of duplicating and distributing Spanish language films. Okay, so here's going to end up being our defendant. The husband and wife, here's their corporation. I got the D for defendants. So they were in the business of duplicating and distributing these films. New Form Inc. is the plaintiff. I got that, the P there. There's the corporate shell right there. Sometimes those are real shells, sometimes those are sham shells, as you've seen in my other videos. But they had the rights to these India Maria pictures. India Maria Pictures were the name of the videos that issued the films. And what happened, basically, let's just cut to the nutshell here. They had a dispute over who had the copyrights and whether or not Barbosa and his wife infringed the copyrights and whether this was a willful infringement. So long story short, there was letters sent back and forth, a letter basically saying by the plaintiff saying, I've got exclusive rights, putting them on notice. And so this got into a dispute. Okay, obviously they couldn't settle their dispute. Although it sounded like the defendant was willing to sort of work and negotiate through it, didn't work out. As I talked about, sometimes like in software licensing audits, the negotiations might not work out, and if so, you could end up in federal district court. Well, that's exactly what happened here. In 2002, the plaintiff files a federal district court action. As you know, these copyright cases are going to be federal jurisdiction, federal case law. So this was filed in the Central District of California, 2002, alleging copyright infringement, alleging willful copyright infringement. So, and we have other videos out on this topic, but if you can prove willful infringement, you're going to get to be able to seek your attorney fees, your damages, statutory damages, whatever you have, and it's going to be potentially big. So, in this case, the lower court gave instructions to the jury on the issue of willful infringement, and what the jury instructions were is if you find that the defendant knew or was reckless about the copyrights of the plaintiff, then you can make a finding of willful infringement. If on the other hand you find there was good faith in the conduct of the defendants, then you can find that there was not willful infringement. So this was sort of what I would call the underlying jury instructions. And the jury heard the evidence, weighed, deliberated on the evidence, and then came back with a finding of willful infringement. Didn't say what ground specifically. It didn't say whether it was because they knew or because they were reckless. So this is very important to keep in mind. It did not say, the jury did not return a finding of whether the defendants knew or whether it was reckless in order to find that willful determination. So that was sort of an open question. But they did return a verdict for $893 big ones. I'm not talking $100 here. I'm talking $893,000. $893,000. So it was a very substantial award for the 10 videos that were supposedly intentionally, willfully infringed. $75,000 per video. So you can see how the damages can stack up here pretty quick. So, not being satisfied with that result, the parties then went, I should say the defendants, I'm going to switch to the blue here. The defendants then went into bankruptcy in 2004 after the judgment. So now you have the creditor, the plaintiff, New Forms Inc., that has the judgment. They're going to want to go try to enforce it, and in order to try to stop them from enforcing this, the defendants go into bankruptcy seeking the relief, the stay, and seeking to discharge this $893,000 as an unsecured debt. Why is it unsecured? Because it's not like your house or something. So it's an unsecured debt, okay? There's no security. So they're trying to wipe out this gigantic judgment in bankruptcy court. So you can see the intensity that might be involved here. Plaintiffs wanting their money. They want to get a judgment. You know, maybe they want to go garnish some wages. Maybe there's some money in bank accounts. Who knows? But they want to go after this money. So you have $893,000. So they're in here in bankruptcy court. The plaintiff, now the creditor, comes into, let me switch over here. Let me switch over here and go in green. So the plaintiff now comes into bankruptcy and files what we call the adversary proceeding, which is the complaint in the bankruptcy court. Very good. I know some of you caught that. It's the complaint in the bankruptcy court. And they were arguing to the judge that this is not dischargeable. This is not dischargeable, Your Honor. Under Section 523A6 of the Bankruptcy Code, 523A6, this is non-dischargeable. Why? Well, because it's a willful and malicious, a debt incurred by willful and malicious conduct. Okay, so that was their argument. So the Code Section 523 says, if you have a debt that's incurred by willful and malicious conduct, you can't discharge it if somebody's going to come in here and make this challenge. So that's what the plaintiffs were doing. They were saying, you're going into bankruptcy, I'm following you right in, okay? So that's how these things go. So they followed him in. The court, basically, the plaintiff tried to pin them down and said, you know, you're bound by this, you know, try to make this finding because we have willful infringement here. You have to find it here, Judge. Because it's there, you have to find it here. And the judge gave partial summary judgment on that in the bankruptcy court. Okay, so the plaintiff, not agreeing with the bankruptcy court, took it up to the BAP. What's the BAP? The Bankruptcy Court of Appeals. Bankruptcy Appeals Court. So they affirmed the decision saying, yes, it was willful here. It's willful here. You cannot discharge. Okay, so that was the basics of it. Even though, again, it wasn't clear here whether this was knowing or a reckless finding of willful by the jury. So just bear that in mind. Final step. Defendant, debtor, still not satisfied with the outcome, says, I'm going to the Ninth Circuit Court of Appeals for relief. I'm going to take it all the way. Okay, so they appeal from here to the Ninth Circuit Court of Appeals. That covers California, Arizona, the West Coast states, basically. And the Court of Appeals reversed the decision of the BAP and said, no. You guys got this all wrong. You got this all wrong. You don't even know if it's knowing or reckless, the reason that they found willfulness here at the early stage. You don't know that. You have to know that. Why? Because the Ninth Circuit Court of Appeals said that willful and malicious, under this section of the statute, 523A6, you have to show both. Not one or the other, both. And since there was no finding on the issue of malice, Okay, the district court made no finding as to malice, and the willful finding by the jury was sort of let's just call it wishy-washy, because we don't know which one it was. Why did they find that it was reckless, which is sort of like, oh, you know, bulldozer, I just consider like a bulldozer to be reckless? Or was this something that they actually intended to infringe and cause that injury? So because they didn't know, the Ninth Circuit Court of Appeals in the Barzos case says, no, this has to be remanded back to the bankruptcy court to make these findings. These findings have to come down before you're deciding whether or not this is dischargeable under 523A6. Are you following the logic here? I know that's a lot of stuff. I know it's a little confusing, but the court talked about willful is deliberate intentional injury. Malicious requires 4 factors. Wrongful act done intentionally, causing injury and without just cause or excuse. So you may have, in analyzing the malicious prong, you may have some just excuses, some things on why you were infringing, some good faith reasons and beliefs. So the court remanded that back, and that's where it stands. So if you're a creditor in a copyright willful infringement case, that's going to be your burden to prove both the willful and maliciousness and make those findings a fact. Okay, so that's it. That's the In re Barzos case. That's a little primer on adversary proceedings and how those go down. The non-dischargeability of debts is also in there, a little bit of topics on that. More information at adversaryproceeding.com, and if you need a lawyer for your copyright case for an adversary proceeding, keep us in mind. You can find us at adversaryproceeding.com or find out more information at askattorneysteve.com. Okay? Thank you for listening. We're glad you watched this. Feel free to share this video on your social media networks. We'll talk again.